Correct.
So he has more time to complete it.
And the multi-offender DUI school was imposed in what case?
In case
And
20,
his misdemeanor case, Judge.
20 CT, 15.
Gotcha. And this sentence is to run concurrent with that, run at the same time as that, 23 CT 1550. Mr. Robinson, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay. You can put your hand down. Mr. Robinson, so did you understand everything that I just stated on the record?
Yes, sir.
Do you agree to that?
Yes, sir.
Okay. If you'll initial the revised plea agreement. Please. Mr. Robinson, did you read the plea agreement?
Yes, sir, I did.
Do you understand it?
Yes.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, I did.
Thank you. Mr. Robinson, I do accept your plea. You're sentenced in accordance with what I just previously stated. Let me ask you this. Your attorney asked to waive the $40 per month cost of supervision. How much money have you averaged making per month before you were incarcerated?
It's up and down. Depends on workflow. Maybe around 800 to 1,200 a month sometimes.
Okay. How did you afford Mr. Tony?
Family
Okay.
and my savings.
And I'm sorry? In your savings? Okay. How much do you have remaining in savings?
After these days in, there ain't very much left.
How much?
Probably $300-400.
Okay. Mr. Robinson, I do waive the cost of supervision. Okay? Thank you, sir.
Judge, for the record, the state will be supplying a score sheet later. We just asked that the defense have no objection to the score sheet.
No objection, Your Honor.
And it's not a downward departure,
Correct.
Okay, good. Thank you, Mr. Robinson. Good luck to you, sir.
That's all I have, Judge. May I be excused?
Yes, sir. Thanks,
Good seeing
Mr.
you,
Attorney. Mr. Rare. Morning, Mr. Rare. Hadn't seen you in a while.
Good to see you, Judge.
Good seeing you.
I've just got one this morning, Judge, Mr. Eric Mountain. He's an inmate. And Judge, we're here this morning on a motion for bond. I did speak with the state regarding his case. It's
Okay,
22.
Is this under a name?
Try under the Lupello
It's under
firm,
Lupello.
Judge. Yeah,
Yes.
usually they'll all get filed under the same name.
Okay, yes, sir. Mr. Mountain.
I've spoken with the state about the bond motion in this case. The state has advised me they would be willing to stipulate to a $2,500 signature bond if the court would approve that.
And this is Mr. Mountain, correct?
Correct.
Rachel, are we getting Mr. Mountain? Thank you. Is Mr. Mountain on the pretrial docket?
He was set for pretrial and for bond hearing today, Judge. So we didn't court date.
Hello, Mr. Mountain.
Good morning.
Good morning, sir. What Mr. Rare just stated before you came out is that the state stipulated to a $2,500 signature bond. So I agree to that. That's your bond. And it's modified for that. Only a BOP case, or there's a new case also?
It's just, he's got a new misdemeanor charge, Judge, down in county court, but this is not before you.
Okay, so when are we going to set this case?
We can set it out. A month, 4 to 6 weeks out, Judge, if you give me time to work with the prosecutor on the misdemeanor case.
Okay. So, Mr. Mountain, I'll see you back here it's either going to be October 19th or November 16th. Which one would you like?
If we could have. Correct, I'll talk to you about that after the court today. If we have November 16th, Judge, I'll try to advance on my docket if I can.
November 16th at 9 o'clock. So I'll see you then. Thank you, sir.
I'll provide the order this morning, Judge. Thank you.
Thank you. Mr. Kett?
First I'm covering for Mr. Harper on Michael Rogers, 22 CF 3127. Your Honor, Mr. Rogers has a new law violation that was transferred to...
Hold on one second. Let's see.
Mr. Rogers has a new law violation that has been transferred to the technical division to run with enforcement. And I believe this one was supposed to go with it, but I don't know what exactly happened. So I'm assuming the state is going to transfer that back to the
I think that's in accordance with the administrative directive. Mr. Rogers, so you're in front of Judge Kett. Do you have any idea when you will be?
10-9 is his next court date for pre-trial conference, so I would enter denial on Mr. Harper's behalf for today's purposes, so that's on the record, and ask that it track with his new law violation. I apologize, I don't have that case number, but I know that it is set for October.
Mr. Rogers, so Mr. Harper will see you in jail. Thank you, sir.
And I have one other, Your Honor, who indicated his ride showed up late, so I'll wait a few minutes and see if he can continue.
Thank you. Let me know when you're ready. Ms. Dudley. Good morning, ma'am.
The first one I have is Javon Harrison, 12 CF 1490. Your Honor, if we could continue this once, he has a new law violation in Escambia County. I'm kind of playing phone tag with that attorney. I think we can resolve it if we get one continuance on it.
Okay. How long do you want to continue?
I think maybe October 9th, I believe, is the date.
Yes, ma'am. October 9th at 9 o'clock.
Yes, sir.
You want Mr. Toomer?
Yes, sir.
Good.
Quishon Toomer, 22 CF 2110.
Mr. Toomer, I read through your motion seeking to reinstate bond. It says that you were arrested on August 3rd of this year, charged with driving without a license. Your bond was revoked. The next thing that I highlighted was the charge is constructive possession. Previous attorneys had conflicts and had to withdraw, so there were numerous continuances, and that your attorney is asking for your bond to be reinstated, or that a reasonable bond be set. Ms. Dudley?
That's correct, Your Honor. He did pick up a no valid DL back in August. He's been on a bond for it was almost a year. I have filed on the case. I have gotten the discovery. I don't know if I have all of it, but I have been able to read at least the offense report. This case appears to be, from what I can tell, hasn't changed from what I read in first appearance. Still constructive possession, 3 people in the car, and they charged Mr. Toomer with the narcotics found, I believe, under the passenger seat, and a gun found under a jacket. There were no statements by any parties that I saw in the report. There's no evidence in this case that even shows that he exercised, I believe the law says, exercised control over those items. We're just asking for his bond to be reinstated. He's not a flight risk. He's come to court every single time I'm on this case. He has no prior failure to appears. I believe he has no prior felony convictions. We are fighting this case. Hoping obviously to resolve it sooner than later, but obviously I just got a few weeks ago. So.
Thank you to the state.
Judge, Mr. Toomer had also had another driving without a license. Shooting at or into a building, into an assault on.
How long ago was that?
That was a 2021. So he
showed that the suspected fentanyl was almost 14 grams. It was over 13 grams of fentanyl.
Yes, ma'am.
I'm sure Your Honor had the opportunity.
Can your,
Something's speeding back.
Yes, ma'am.
I'm sure Your Honor had the opportunity to read through the probable cause affidavit, so I don't want to review something that Your Honor's already seen. So at this point, he's charged with the gun that was directly under the seat and the fentanyl that was found in his location. So we're talking about that he committed maybe not the exact same crime as the case that he has his bond revoked for, but it's the same crime that he just did last year as well, that we're back doing the same thing again. So this particular defendant has no regards for the laws of the state judge, and we ask that his bond remain revoked.
Yes, sir. He hasn't been convicted or pled to any crime carrying a firearm, hasn't been convicted of any of those crimes. He did plead as a plea of convenience for an assault, but there was no evidence. The reason why, there was no evidence of child abuse. There was no evidence of him shooting. There was evidence of him arguing with somebody else in the street. There was no evidence he even had a firearm. And that is why that case resolved that way. To say that he's committed the same crimes, he hasn't been charged with trafficking, he hasn't pled to any trafficking. And in this case, the state just said it was in his proximity.
He hasn't been charged
I mean,
with trafficking?
hasn't been convicted of any trafficking prior, or pled to any trafficking charges. To say he committed the same crimes, he hasn't committed the same crimes. Number one, he's alleged to be innocent. Number two, he's never pled to any crimes similar to these. The state just instead said in their statement it was in his area. Well, he's in a vehicle. There are 3 people in the vehicle. The only person they decided to charge was Mr. Toomer. The state hasn't mentioned any evidence that said he exercised control over those items. They haven't mentioned any evidence that said that he knew those items were there, which is a requirement for possession, especially constructive possession. So that's what he's charged with. It wasn't on him. I know the court probably has read the PC. We argued this at first appearance as well, which is why he was given a signature bond. Because of the fact that he was in a car, a gun was under a jacket, they can't prove he had knowledge of it. And the drugs, depending on when you read in the report, one part of the report said the drugs were under the front passenger seat. He was in the back seat. So he hasn't been convicted previously of these type of charges. He hasn't continued to commit these type of charges. He has a prior assault, misdemeanor assault. That's it, as far as the charges that the state has brought up. We do not believe he's a danger to society. There's no evidence he possessed these drugs or exercise control over the drugs, which is a requirement under the law. We're asking for the bond to be reinstated. Based on that, he's not a flight risk, and then we'll continue to fight the case.
Okay, thank you. Mr. Toomer, I have to comment that Ms. Dudley is a heck of an advocate. I mean, she's done her homework, she's looked through everything, she's picked it apart. I mean, her argument today shows that. And so I'm glad for that. From the systemic point of view, the whole system, it works better if everybody does their job better. However, respectfully, the motion to reinstate bond is denied. The prior driving without a license causes the court concern, as does the other information that I have. But I'm certainly not denying it because of the lack of advocacy of your attorney. I don't think she could have done any better job. When will I see Mr. Toomer?
I believe we are set in November, I believe.
November 13th. I'll see you no later than the 13th.
Yes, sir.
Thank you, sir.
That's all I have, Aaron. Thank you.
Thank you, Ms. Dudley. Next is Ms. Merrifield.
Good morning, Your Honor.
Good morning, ma'am.
Brittany Merrifield on behalf of Chad McKendry. In 2020 CF 2328, Judge Mr. McKendry is present and approaching. We're here today on his violation of probation, Judge. I have spoken with the state. We are requesting a continuance. Mr. McKendry is actually supervised out of Bay County. That's created a little bit of problems, even for my office. He's on his 6th probation officer, So gathering the information that he has previously provided to probation, that I have proof of most of those requirements, has become difficult. So I'd be requesting a continuance just to give us a little bit more time so that we can provide all that proof directly from probation so that the state can verify that information that he has completed some of those requirements.
Any objection from the state?
No objection, Mayor.
How long do you want to continue?
I believe Your Honor has a October the 9th.
Yes, ma'am.
I think that would be sufficient, Judge. I'm going to do everything I can to get the information as quick as possible.
Mr. McKendry, I'll see you on October 9th at 9 o'clock. Stay in touch with Ms. Mary.
Yes, sir.
Thank you, sir.
Thank you, Judge. That's all I have this morning.
Ms. Jakewood, you have your client yet?
I am still waiting, Your Honor.
Okay, thank you. Datarian Grant? Datarian Grant? Mr. Grant? Okay. How old is Mr. Grant? Mr. Grant, how old are you?
23.
23? Do you have seeing problems? Eye problems?
Yes, conjunctivitis providers in both his eyes.
Okay. So, Mr. Grant, let me pull up my homework for you. Okay. Mr. Grant, I've read through your motion, but before I do that, are you representing yourself because you can afford a private attorney or because you don't want a public defender and you qualify? Tell me why you're representing yourself.
I can't afford a public defender.
Oh, and I'm sorry, Mr. Grant, let me go back. You're not asking to modify mine, you're asking to terminate your probation, so I understand that. Okay, so I read through it, here's what it says. It says that you were placed on probation on December 9th of 2020. Supervision was for 3 years. And it was interesting the way that you drafted your motion. You said there were violation papers filed. And when I read it before I looked at your record, I put "were not?" question mark, and then I went back and looked at the record, and you were being accurate in your description of that. So if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir. You can put your hand down. So, Mr. Grant, what else would you like for me to know other than what's in your motion?
According to me being released off of probation.
Yes, sir. Correct.
Well, I've got all my hours done for community service and my therapy hours.
Right. So you've done everything. If I don't terminate your probation today, it'll only be a few months down the road before it terminates on its own on December 9th of 2023, if you're accurate in when you were put on probation. Anything else you want me to know? Mr. Grant, anything else?
Yeah, this is really preventing me from getting a lot of jobs. So I would like it to be terminated today.
Okay. To the state regarding Mr. Grant's motion?
Judge, as you noted earlier that there was a violation, however, he was reinstated with some additional community service work. We were able to confirm with Officer Rose that all of his conditions have been completed. We reached out to the victim's mother, and she has no position on early termination. So state's objection would be solely due to the nature of the underlying charges.
Okay, so it wouldn't be, your argument is not that the motion to terminate probation a few months early is because on December 9th, it's interesting, he was placed on probation on December 9th of 2020, his motion says, and then the violation report says on December 9th of 2022, he was arrested on possession of 28 grams or less of marijuana, and on that same date in 22, providing a false ID to law enforcement.
Yes, Judge, those were out-of-state charges that Ms. Rose filed the violation report for. As a result of that BOP, he did an additional community service work and was reinstated.
Okay. Mr. Grant, I'm smiling, and the reason why is the state's being very particular in what they're saying, but the reasons why I would not grant your motion to terminate probation would be because of those the two offenses that occurred last year. And since the state's saying you did the additional community service hours that were attributable to those two things, and they aren't arguing I should deny your motion based on that, your motion to terminate probation is granted. So your probation is terminated, okay? Thank you, sir. Good luck to you, and I hope you get a job.
All right, thank you.
Thank you. Thank you so much. To your mom.
Your Honor.
Yes, ma'am.
Apologies. I have Robert Stoudemire on this morning's docket at 23, the case number is 23 CF 1187.
Yes, ma'am.
I did reach out to him, and he is having some trouble with his ride, didn't show up on time, and he is unfortunately staying in Panama City. He's a gentleman that's here from Orlando. Would it be possible for the court to allow me to just pass him to 1:30, and that way he'll have time to get here?
Yes, ma'am.
Okay. Thank you, Your Honor, and I will return at 1:30. Thank you so much.
Sounds good. See you then.
Appreciate it.
Thank you. Next is Glenn Sholey. Is in the back. 21 CF 1454. Hello, Mr. Sholey.
Good morning.
Good morning. Mr. Sholey, do you wish for me to appoint the public defender if you qualify financially?
Yeah.
How much money do you make per month?
It's different. I mean, I make anywhere from $400 to $600 a week.
Okay.
And I don't work all the time, but I mean, I do have a permanent job. It's just
Okay.
anywhere from $400 to $600 a week. It just depends on what kind of week we have.
Okay. I do appoint the public defender to represent you. Mr. Koch is approaching on your right.
Good morning, Judge.
Good morning, sir.
And I apologize.
This is Mr. Sholey. It's number 10 on my docket, 21 CF 1464. No, 1454.
Your Honor, may I request there's an offer in
Yes,
my new client's case?
I'm trying to look, he's got a new misdemeanor. Judge, it's going to be an incarcerative sentence.
Mr. Sholey had a prior violation of probation that he was resentenced to supervision, keeping his withhold on an aggravated assault with a deadly weapon. So at this point, it's an incarcerative offer.
Judge, may I just have one moment?
Yes, sir.
Judge, thank you. I will be a denied violation, Your Honor.
Okay. And the next date that we have is October 9th. Is that when you wish to set it?
Yes, Judge, please.
Judge, just one second, I want to make sure the court date for the misdemeanor case. It looks like his misdemeanor case is set for 10/9, Judge.
Okay. I can either set it on that same date, or I can set it 3 days later on October 12th.
Judge, we can do the 3 days later, please, the 12th.
I'm sorry, we can do the 9th?
Or the 12th, did you say?
Yes, sir, the 12th, okay.
Can I, please?
So, Mr. Sholey, I'll see you no later than October 12th. Mr. Koch, if it's resolved, the misdemeanor on the 9th, and you can get Mr. Sholey up here and the state knows what's going on, I'll certainly see him on the 9th.
Yes, Judge.
Okay?
Thank you.
Good. Thanks, Mr. Sholey.
Thank you.
Yes, sir. On Zoom, do I have private counsel?
What are you doing?
Yes, good morning, Judge. I'm Chris Rabbie. I'm here on behalf of Justin Matthews. This is an Escambia County case. It's been reassigned to you.
Okay.
The case is 21 CF 2837. It's a violation of probation on a felony battery case. Mr. Matthews is present in my office. Judge, we have had some difficulty in finding out who the prosecutor is on this case. We've got Clara Smith, who sent the notice of hearing for today. He's got a new misdemeanor charge, which has also been reassigned to Judge Angela Mason. That one is currently scheduled for September the 26th for a status conference.
Who is this?
But I don't know that we have a prosecutor on, I don't know who the prosecutor is on this case.
Mr. Rabbit, tell me the name of your client.
Justin Matthews.
And it's an Escambia County case that was transferred here.
Well, it was reassigned to you, but the case was not transferred.
Okay.
And
Yes,
we've
sir.
got Ms. Hurley, who's with the clerk's office, who's president of Escambia County on Zoom also.
And Ms. Hurley, in the future, when you appear for something like this, if you interrupt me early and say, Judge, I'm here for an Escambia County case, can we take it sooner than later? Then we'll handle your case quicker, okay?
Yes, thank you.
Good. Thank you, Madam Clerk, here? No? Okay. So on Mr. Matthews' case, everybody in the state is staring at me, and one of them is shaking their head like, no. So when was it, and I didn't have it on my docket, I don't believe. Okay. So our clerk didn't have it on their system yet. Mr. Rabbie, I'm trying to figure out the fastest way. What about if do you want to pass this case until this afternoon? At 2:30, I've got arraignments at 1:30, and then the state can at least get up to speed somewhat, and they can at least tell you who the state attorney is going to be.
Judge, I've got to be in federal court over in front of Judge Weatherall at 2.
Okay.
I'm not sure how long that's going to take. Can we just set this for your catch-all date of October the 9th?
Yes, sir. Sir.
And then deal with it at that point. And I've left several messages and emails for the Escambia County prosecutor that did the notice of hearing for today.
Everybody will get their head together on this. Before then, I'm glad to see your client's not incarcerated, so that makes me feel better about the continuance and the confusion. At least it doesn't keep your client in jail. So, Mr. Matthews, I'll see you back here via Zoom on October 9th at 9 o'clock, and we'll all, including me, will do our homework and get up to speed, okay?
Yes, sir. Thank you, Judge.
Thank you, Mr. Rabbit.
Thank you.
Thank you, Madam Clerk.
Thank you. Have a good day.
You too.
And Judge, Mr. Joseph Sanchez is in the courtroom. He's with APD from Pensacola.
Yes, sir.
Can we call the two cases that he's here for?
Absolutely, yes, sir.
The first one of those is Ms. Tracy Rosado, who's incarcerated. And I believe the second case is going to be Mr. Dunsford with Mr. Clines. He's also incarcerated.
Thank you. And I'm sorry, the defendant is who?
Tracy Rosado, 23 CF 457. Ms. Tracy Rosado is before the court in 23 CF 457 for some procedural history for the court. Ms. Rosado is found incompetent to proceed, and then the court signed an order for an APD evaluator to evaluate Ms. Rosado. That's been completed by Dr. Klein, who has prepared a separate report. He also has found Ms. Rosado to be incompetent to proceed. There is a letter provided by Mr. Sanchez, who is present in the courtroom from APD, outlining options for the court.
Yes, sir.
I'm saying that only procedurally. I don't believe we're in a position to move forward into a contested competency hearing at this point, because we were trying to gather all of the reports together. I believe that the state does have some concerns. I'll let the state speak to that. But I believe as far as a procedural nature, if we could continue this matter until October 12th, I believe that Mr. Sanchez could be made available on that day. If it's a 2:30 date time, I believe that that would give us time to serve Dr. McDonald and Dr. Klein if there's any questions in a contested type competency hearing.
Okay, thank you. To the state.
That's correct, Judge. At this point, we're not going to be stipulating to the report. Specifically, we're going to be disputing the manner of these restricted placements, so if we could just send this to the October hearing date.
Okay. And I'm sorry, it's October which date?
If we could have October 12th.
Okay, good. And the 12th would be 2:30.
That would be at 2:30, because I would expect testimony from several doctors, perhaps Mr. Sanchez as well.
Mr. Sardo, I did read through all the different reports, and I'll see you back here next month, okay? Thank you, ma'am.
I certainly thank Mr. Sanchez for coming over from Pensacola.
Next is Dunford, who's number 13 on the docket.
Dunford?
This is Wesley Dunford. He's approaching the podium. We did receive Dr. McDonald's evaluation. She did find Mr. Dunford not restorable. However, in reviewing 916.301, the appropriate steps here, I believe, would be for the Agency for Persons with Disabilities to have a psychologist evaluate Mr. Dunford. Their last evaluation took place in the spring of 2022, so specifically we need a recommendation on whether or not Mr. Dunford is restorable, and that would be, frankly, Your Honor, in preparation for a potential motion to dismiss under 916.303, but that motion would be untimely without that evaluation. So I would ask the court to keep Mr. Dunford's case on a monthly cycle just for status, so we can make sure that we're not just kicking this 2 months down the road and then finding out at the last minute that nothing's been done. So I would ask the court to put Mr. Dunford's case on either the October 9th or October 12th docket just for status, and I'll file a waiver so the court of security doesn't have to transport him. But I will submit an order to the court. Mr. McKinney provided me Mr. Rosado's order, so the court should be seeing that with Mr. Dunford's name on it later today or tomorrow for the agency to appoint their expert.
Okay, good. So you'll give me the proposed order on appointing the agency?
Yes, sir.
Good. Mr. Dunford, so I'll see you back here on October 9th at 9 o'clock, okay? Thank you, sir.
Oh, Your Honor, could we do that on the 12th? Because Mr. Sanchez is already going to be here.
Oh, okay. Yes, sir. So October 12th at 9 o'clock. Thank you. Thanks, Mr. McKinney.
23CF 1070. And Your Honor, may I approach with the plea form?
Yes, sir.
I have a copy just to what counts in this case.
Thank you, sir.
And just for the court's information, sentencing on this will be set off for January 11th, 2024.
How do you pronounce your last name? Resitar. Good. I'm glad I asked because I'm going to butcher that. Mr. Resitar, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth? So help you God? Yes, sir. Thank you, sir. You can put your hand up. Mr. Resitar, did you read the plea agreement?
Yes, I did.
Do you understand?
I do.
Did you discuss it with your attorney?
I have.
Did he answer all of your questions?
Yes, he did.
Are you satisfied with his representation?
Yes, I am.
Did you sign the plea agreement?
I did.
Okay, hold on one second. Let me see what the sentence is going to be. Okay. Mr. Resitar, are you currently under the influence of any drugs, alcohol, or medication?
No, sir.
Have you ever been
Medication?
Yes. What's the medication?
Diabetes medication, kidney disease.
Okay. Are you currently under the, have you ever been diagnosed with any mental illness or condition? Are you being treated for any of those?
No, sir.
How far did you go in school?
Through high school.
Do you understand that if I accept your plea, that you're waiving your right to a trial by jury?
Yes, sir.
Do you believe it's in your best interest to enter the plea?
Yes, sir.
Has anyone forced, threatened, or coerced you into entering it?
No, sir.
Has anyone promised you anything other than what's in the written plea agreement?
No, sir.
The opposite of that is, has Mr. Koch or anybody else said to you, Mr. Resitar, if you do not enter this plea, you shall be sentenced to 15 years in prison or any other definite sentence? Okay, listen to my question. Okay. Has anybody told you, if you don't enter this plea, not you may be sentenced to something, but that you shall be sentenced to?
No, sir.
That's just to make sure that no one's coerced you into entering this program. Mr. Resitar, I do accept your plea. I find that you're alert and intelligent, that your plea is freely and voluntarily entered, that you understand the nature of the charges against you, and are represented by competent counsel with whom you state you are satisfied. I find that there is a factual basis for acceptance of the plea. So the sentencing will be on what date? Because I don't even have the docket for next year, at least in front of me.
Your Honor, on the plea form I put January 11th, 2024. I saw we had a miscellaneous court date scheduled already.
Okay, I mean, yes, sir, we do. Okay, so January 11th at 9 o'clock. I'll see you then. Okay, thank you, sir.
Your Honor,
yes, sir.
if I may, just to put on the record, and I did speak with my client, and I instructed him that on the January 11th, 2024 date, he must be here for sentencing, and in between now and then, during the arrest, that this offer will be revoked ultimately, and we'll have to appear before you to get a sentence. And also, if he fails to appear on that date, once again, the offer will be revoked, and when he is arrested on that outstanding warrant, of course, we'll have to appear before you, and the judge yourself will have to impose that sentence.
And he could be sentenced up to the maximum that's set forth in the plea agreement, correct?
Yes, Your Honor.
Mr. Resitar, do you understand that?
I do.
Do you still want to enter the plea?
Yes, sir.
Thank you, sir. I'll see you in January.
Thank you.
And Your Honor, if I may, up until that January 11, 2024 date, he will still be on pretrial services with all of the previously imposed conditions. And the score sheet would reflect 117.475 minus Department of Corrections, the lowest permissible score with a maximum of life.
So it's not a downward departure?
It's not.
Okay. Thank you. Thank you. Thank you, sir.
Thank you.
Mr. Koch, who's next?
President,
In the gallery, Mr. McKinney, do you have any in the gallery?
I do have one individual in the gallery, Mr. Youngblood. Mr. Youngblood's actually in the 130 docket for arraignment. And we're going to be entering a plea of not guilty.
Oh, Mr. Youngblood. Mr. Youngblood's the last one on the docket for 130?
Yes, Judge.
23 CF 1786.
We would acknowledge a receipt of a four-count information, waive its full weighting, and enter a plea of not guilty. This appears to be already scheduled for pretrial on November 13th at 9 a.m. We'd like to keep that court date.
Mr. Youngblood, I'll see you on November 13th at 9. Stay in touch with Mr. McKinney, okay? Thank you, sir.
I believe there is another gentleman here from the 130 docket that I don't see in the courtroom. Everybody else I have is incarcerated.
Your inmates?
We don't have his inmates upstairs. We have Mr. Koch. Mr. Koch.
I'll go get them. I'll defer to court security.
Thank you.
Are you ready on Mr. Klein as well for his?
I don't have his poll because he wasn't in here.
Okay.
I have Dustin on Zoom. Who is Dustin? Not Mr. Durrell. Nope. Mr. Dustin, if you'll take your mic off mute and tell me your last name.
I apologize, Your Honor. My name is Dustin Strong.
Strong, okay. And who represents you, Mr. Strong?
There's actually no one representing me yet, sir. I had a lot of difficulty with the request for legal counsel with the online services.
He's set for 1:30.
Okay, so you're on the 130 docket. Hold on, let me grab that, okay?
Number 26.
Yes, sir.
26.
Dustin Strong, 23 CF 1659. To the state looking at the charges, do you have any offer for Mr. Strong?
Just 1 second.
Sure.
Judge, the offer is going to be a withhold and 1-year probation with court costs, substance abuse evaluation, and 12 hours of community service.
Mr. Strong, have you ever been on probation before?
I was on probation in Tennessee. Yes, sir.
Okay, so you've got the right to an attorney if you want me to appoint one, and you qualify financially, I'll do that. It would cost you $150. You have the right to a trial, either representing yourself or represented by counsel. You also have the right to waive both of those and accept the state's offer of a withhold of adjudication, 1-year probation. You'd have to pay the court cost. There'd be $40 per month cost of supervision. Submit to a substance abuse evaluation within 30 days from today. Begin any treatment if it's recommended within 60 days from today, and perform 12 hours of community service work. So I see you furrowing your brow. If you want me to appoint an attorney, I can do that.
Yes, sir. I would definitely appreciate that. Yes, sir.
Okay, how much money do you make per month, Mr. Strong?
Well, to be honest with you, the situation that I'm currently facing is it's put a damper on my employment situation. I'm not eligible to make anything to what I was making at the time, at this current present time. Between jobs, I can make anywhere from $1,100 to $1,200 a week.
$1,200 per week?
Yes, sir. I'm a journeyman iron worker.
Okay. Mr. Strong, you're probably not going to qualify for the public defender. You're going to make probably double what is traditionally required to qualify for a public defender, so I'm not going to appoint a PD to represent you today. If you want to fill out a financial affidavit with the clerk, you can do that. It's a $50 application fee. If the clerk denies your qualification, well, before that, when you fill it out, load it up with expenses, concerns you have about future employment, those things. And if the clerk denies your eligibility, you can appeal it to a judge because we have more discretion than the clerk does. So if you want to do that, you certainly can, okay?
Yes, sir. I do want to, you know, for the record, be clear that that is what I was making prior to these charges. I've still yet to find employment at this present time.
How long have you been unemployed?
Since pretty much since I bonded out.
Which is when?
Was it a couple months ago? September.
So you've been unemployed for 2 months?
Yes, sir.
Okay.
Yes, sir.
Mr. Strong,
I've had the occasional DoorDash. You know, I am a DoorDash driver as well. I've had that's kind of kept me afloat so far.
And how much money have you made per month doing that?
Man, if it's a perfect week, we're probably looking at maybe, I'd say probably a good week would be $300 for the week. That's,
Mr. Strong, I do appoint the public defender to represent you. Mr. Koch is approaching the lectern. Do you have the information? So, Mr. Strong, Mr. Koch is receiving the information, which is the charging document against you, and then him talking to say.
Yes, sir.
We entered not guilty, Your Honor, and if I may provide my phone number to any client.
Sure.
I'll be your attorney, Mr. Thomas Koch. Can I give you a phone number? Do you have a pen and paper ready?
Yes, I do.
Tell me when you're ready.
I'm ready whenever you are, sir. Just to repeat that, sir, I have 850.
That's correct, and you can call today and schedule an in-person or telephone conference with me, okay?
Thank you very much, sir.
So I'll see Mr. Strong on November 13th at 9 o'clock. Mr. Strong, I'll see you then. Stay in touch with Mr. Koch, okay?
Yes, sir. Thank you, Your Honor.
Thank you, sir. Okay, to the PD. We get the folks out of the gallery whether they're waiting for inmates or defense. Yes, sir.
We have Kelly Patterson, she's an inmate.
Okay.
With Mr. Koch.
So you have Kimberly Nicole Patterson.
Right, right, on the docket, we have Kelly Patterson, but present, we have Kimberly Nicole Patterson, correct?
You ready? Yes, I'm sorry.
All right, move on. And Judge,
Good morning.
Just for the court's awareness, I spoke with my boss and we agreed that the best course of action would be to amend the information to include Kimberly Nicole Patterson as the name on the information. For the clerk's benefit, we also put the AKA Kelly Michelle Patterson. If you don't have that on your thing, I do have a copy of that file of amended information, but I just wanted to let the court know that we should be good to go to play this today.
Okay. Good. Yes.
Yes, Your Honor, the state did provide that new information, so we're all up to date. So next to me is Kimberly Nicole Patterson, and she will be entering no contest plea, and she will be adjudicated guilty, will be credit for time served. There'll be $150 for the defense costs, and $515 for the court costs, if I may approach the plea form.
Yes, sir.
And also just, I wanted to make sure, because I know we can't share like social security numbers, but if Ms. Kimberly Patterson can put on the record what her date of birth is, just so that we have that on the court record, I would appreciate that as well, just to make sure.
Ms. Patterson, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you, ma'am. Put your hand down. Ms. Patterson, let's start with that. What is your date of birth? Ms. Patterson, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you sign?
Yes, sir.
Ms. Patterson, I do accept your plea. Has Ms. Patterson been adjudicated guilty of a felony in the past?
Yes, sir.
Okay. Ms. Patterson, I do accept your plea. You're adjudicated guilty. You're sentenced to credit for time served. You'll need to pay the $150 public defender's fee, $515 in court costs. How long will you need to pay that?
6 months if I can.
Okay, yes, ma'am. If you fail to pay it within 6 months, it will go to a civil lien or judgment. Okay?
Yes, Your Honor.
Thank you, ma'am. Good luck to you.
And Judge, if I may, can we put in for the cost when she gets released? Because I know she has a hold out of Mississippi. I don't know if we just put 6 months after the date of release.
Well, I think it's going to be hard for the clerk to monitor that.
We don't know.
But let's just do the 6 months.
Yes, Judge.
Yeah, thank you. Thank you, ma'am.
Yes, Judge, I do have another client in the courtroom, Ms. Tina Stone, who's present and approaching.
Hello, Ms. Stone.
Hi, Judge Brown.
Yes,
Yes, Your Honor. I did provide my contact information to my client, and she knows to schedule an appointment with me. But if I may request an offer in this case from the state on the record for Ms. Stone. It should be the DOP.
Has she completed her mental health evaluation? She doesn't have it.
Speaking with the state, there's some issues with, it was an option of 90 days. At this time, we'll deny the violation, and if we set this for the 10-9 date.
why don't we do it October 12th?
I'm sorry.
So, Ms. Stone, I'll see you back here October 12th at 9 o'clock. Stay in touch with Mr. Koch.
Okay, thank you.
Thank you, ma'am.
Next, we have A.E. Pearson with Mr. Koch. Who's the name?
Thank you.
Your Honor, Dr. Pearson, can I do something in the audience?
Yes, it is. Yes, sir.
I heard yes.
Thank you.
Your Honor, may I just have one brief moment?
Hello, Ms. Pearson.
Thank you, Your Honor.
Yes, Your Honor.
My client will be denied violation. If we could set it for that 12th date, Your Honor, but my client will also be in front of you on the 21st for her new law violation for arraignment that date. I told my client that we could certainly enter a plea to everything on that 21st also.
So you want to just track this with that case?
Yes, that'd be perfect for the 21st.
So I'll see you back here on next week, okay?
Thank you.
Thank you.
Thanks, Judge.
Mr. Hunt?
Yes, Your Honor. Ricky Nettles.
Mr. Nettles. Mr. Nettles sat as far away from me as he could.
To be fair, I would have done the same thing. I was a certified backbencher. Your Honor, this is Mr. Nettles, an 18 CF 3275. He's going to enter an admission to violating supervision. The agreed upon disposition today is a re-sentence to time served. The supervision will be revoked and terminated. The outstanding financial obligations will be sent to liens or collections. He'll be assessed $100 cost of prosecution, $150 in public defender fees, and he's been previously adjudicated. May I approach?
Yes, sir. Thank you, sir. Mr. Nettles, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand out. Mr. Nettles, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Mr. Nettles, I do accept your plea. You're adjudicated guilty. You're sentenced to credit for time served. Your supervision is revoked and terminated. You'll need to pay the $100 cost of prosecution, $150 public defender's fee. All outstanding financials will go to a civil lien or judgment. Okay?
Yes, sir.
Thank you, sir. Good luck.
Thank you.
No.
Okay. Next we have Tristan Polk with Mr. Koch. Mr. Polk, straight up to that podium.
Hello, Mr. Paul. Good, how are you?
Good. Yes, Your Honor. My client will be denying the violation. If the new law violation is set for arraignment in front of you on the 12th, Your Honor, of October, I'm asking if we could set this also on the 12th.
Yes, sir. Madam Clerk, setting it for the arraignment date, is that going to be a problem?
I'll reset it in the morning. It's just that if anything goes on the felony committed docket that doesn't have the court and it has felony plea, it won't populate in the docket, so I just have to set it on the miscellaneous docket.
Okay.
I can still set it some day.
Okay, good. So, Mr. Polk, I'll see you on October 12th. Okay? Thank you, sir.
Next we have Stephen Rogers. He's on here. Frank, is Dunford still up here? Is Dunford still up here or down?
Yes, sir.
Dunford.
Good morning.
Morning, sir.
This is Stephen Rogers, Judge. He's on the AM and the 130 down there.
Okay, thank you.
Okay.
Yes, Your Honor. My client, information has been filed for the new law case. My client would, if I may request, could he hear the offer now that the filed information of the new law from the state in this matter?
So you acknowledge receipt of the information on the arraignment?
Yes, Your Honor.
Okay. And you just deny, generally deny?
Correct, Your Honor.
Okay.
Judge, we sent an offer in the paperwork for the discovery. The defense has it. Yes, thank you, Judge. So we'll be denying the violation, and if we can set this for that October date, Your Honor.
Okay, so we've got an arraignment, and then that's set for pretrial on November 13th.
I believe it is, Judge, on the new law.
So do you want this case to track with that new law?
Yes, please.
Okay. So, Mr. Rogers, I'll see you back here no later than November 13th on both of your cases.
November 13th?
November 13th. If the state offers you something that you want to accept before that date, Mr. Koch can set it for a hearing then. If Mr. Koch wants to file a motion, he can set that hearing before.
I want to move forward with the trial.
Mr. Koch will inform you on all your rights, and he'll, if you want to do speedy trial, and Mr. Koch can file that.
Can I have just one more?
Yes, sir. Thank you, sir.
Thank you, Judge.
Next is Cecil Rutledge. Come on. Mr. Rutledge, straight up to that podium.
Well, Mr. Rutledge.
Yes, Your Honor. My client, this is Cecil Rutledge, standing next to me, Your Honor. My client will be entering an admission for violation this morning, and it will be adjudicated guilty, 6 months at the Osceola County Jail. The cost prosecution of $100, defense cost of $150, and there'll be credit for all time served. My client was originally, this was a withhold in this matter, but it will be an adjudication of guilt, and I did explain. If I may approach with the
Yes,
principal.
sir. Mr. Rutledge, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir. Just making sure they aren't talking about your case. Mr. Rutledge, did you read the plea agreement?
Yes, sir.
Do you understand?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement? Mr. Rutledge, so you understand that you're waiving your right to an evidentiary hearing where the state would have to prove the violation of probation against you? And you understand that you'll be adjudicated guilty as a felon, correct?
Yes, sir.
Mr. Rutledge, I do accept your plea. You're adjudicated guilty. You're sentenced to 6 months in the Okaloosa County Jail with credit for all time served. You'll need to pay the $100 cost of prosecution, $150 public offender's fee. God bless you. How long will you need to pay the financials after you get out of jail?
I could probably start paying them maybe a month, 2 months.
Okay, so if we do 6 months for you to pay them, if you fail to pay them within 6 months, then they'll go to a civil lien or judgment.
Yes, sir.
Is that revoke supervision?
Yes, I'm sorry, to terminate and revoke supervision.
Yes, thank you very much. Your supervision to revoke and terminate. Thank you, ma'am.
Mr. Rutledge.
Thank you.
Next is Joshua Salerno. Straight up to that podium.
Morning, sir.
Morning, how are you doing?
Good, how are you?
Optimistic.
Judge, may I have a brief moment?
Why not? He's asked why.
Your Honor, may we pass this up? My client may accept an offer that's on the table right now. Can we pass them up so I can talk to him about that?
Yes, sir. So pass it until later this morning?
Yeah,
You want this afternoon?
this afternoon would be great.
So, Mr. Salerno, I'll see you at 2:30 this afternoon.
Thank you.
Ricky, you'll make sure to keep
Next is Ruben Stokes.
Thank you.
Ruben Stokes.
He's also on the $130 as well.
Yes, Judge. We give him the state did file information that the new charge, the new law, it should be stated in the offer on the record if a client can hear that. Thank you.
Okay, so you acknowledge receipt of the information?
Yes, Judge.
And you enter a denial?
Yes, Judge.
at this point, the offer is an adjudication of guilt, 10 years DOC, followed by 36 months probation. Revoke and terminate his current supervision, be court costs, 100 hours of community service, no contact with the victim in 23 CF 1823, no trespassing at the residence in 23 CF 1823, and complete the anti-theft course. The reimpose of the $600 restitution from the VOP case, and a letter of apology to the victim in 23 CF 1823.
Yes, Your Honor, I have just a brief moment. Thank you, Your Honor. With the denied violation, you stated, and if we get this pushed out to, I guess, to track the new law, the 1113 date, Your Honor?
Yes, sir. So, Mr. Stokes, I'll see you on both of your cases on November 13th.
Yes. Can I have one moment, Judge? Yes. Correct. Thank you, Judge.
Thank you, sir.
Next, we have John Smedley with Mr. McKinney.
Thank you.
Judge, this is Mr. John Smedley before the court. He's here in 23 CF 1014. Additionally, there's a number of other cases, 22 CF 1961 through 1964, and 22 CF 1685. There's a pending competency evaluation. I spoke to Dr. Zuma's office that he was evaluated on the 9th. So there is a report that should be inbound. That should turn around pretty quickly. I'd like to set this for 10/9. That's the next available court date. But if I receive that evaluation in time for us to have a hearing next week, I'd like the ability to have this on with proper notice.
Absolutely. So, Mr. Smedley, I'll see you no later than October 9th, but hopefully I'll see you next week when the report comes in. Thank you, sir.
Next, we have Lionel Tercero.
Good morning, sir.
So, Mr. Tercero, before court at 23 CF 287, we reached an agreement. Mr. Tercero is going to be admitting to violation of probation. Originally, adjudication was withheld. The state's agreed to keep the withhold. This probation is going to be reinstated to complete the original terms. There's a $100 VOP fee, $150 cost of defense. May I approach with the agreement?
Yes, sir. Thank you. Mr. Tercero, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Do you swear? You can put your hand down. Mr. Tercero, not much of a downside to you on this, other than the $100 cost of prosecution and $150 public defender's fee.
Yes, sir.
Did you read the plea agreement?
Yes, sir.
Do you understand?
Yes, sir.
Did you sign it?
Yes, sir.
I do accept your plea.
Thank you.
Adjudication has continued to be withheld.
Thank you.
Your current supervision is reinstated. You need to pay that $100 and the $150.
Yes, sir.
Thank you, sir. Good luck to you.
Judge, I'd like to stress, Mr. Tercero, that the state has agreed to keep the withhold adjudication and reinstate the probation. That probably won't happen again. So that includes driving while license suspended.
Mr. Tercero, it is unique for the state. When I heard continue withhold, was almost an excited utterance from the court for me saying, good, because there's less of a downside to this. So do acknowledge that. If you come back, that may not be the case.
Yes, sir.
Thank you, sir.
Sir.
Next is Trevor Thomas.
Hello, Mr. Thomas.
Good morning.
Judge, Mr. Thomas is before the court in 23 CF 1407. And he is scheduled here for a bond hearing today. And I believe that the state is going to stipulate to our bond request. That being said, I'm going to ask that I have the ability to call Mr. Thomas's father, who's present in the courtroom, because I know that he wanted to testify in the courtroom. He had a medical procedure this morning, but he still made it here for his son. So may I call Kenny Johnson?
Certainly. Mr. Johnson. Mr. Johnson, if you'll come to the stand.
You'll stand right here, face the clerk, raise your right hand.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Right, you have a seat.
I just so.
Good, sir. How are you?
Right into that microphone up front, you can move it if you need to.
Mr. Johnson, could you please state your name for the record?
My name is Kenny D. Johnson.
And who is Trevor Thomas?
That's my son.
Normally, where does he live?
He long lived in Baton Rouge.
In Louisiana?
Baton Rouge, Louisiana.
Now, I just referenced to the court that you had a medical procedure this morning. Is that correct?
Yes, sir.
Is there anything from the pain medications that's affecting your thinking?
No, sir. No, sir.
Okay. Did you have your wife drive you from
Yes, sir.
your procedure? Mr. Johnson, Mr. Thomas is alleged to have failed to register as a sexual offender in Florida.
Yes, sir.
Did Mr. Thomas come to your house at some point in time in this year?
Yes, he did.
Can you explain to the court what happened?
He came, my daughter was moving back to Louisiana with 4 kids, and she asked him to come down. He made a mistake by not contacting the police, but he came across the line for one night and moved my daughter back to Louisiana. He only was here for one night.
So was Mr. Thomas even in Florida, to your knowledge, more than 48 hours?
No, sir.
Do you believe that he has a valid address in Louisiana?
Yes, sir.
That the court lets him out on bond?
Yes, sir.
And do you have regular contact with your
Yes,
son?
sir, I do.
I have no further questions for Mr. Thomas.
The state questions for the father.
No, Your Honor.
Mr. Johnson, thank you for being here.
Thank you, sir.
Really appreciate it.
Yes,
Thank you, sir. It adds a lot. I did my homework. I read through the arrest report, and certainly what you told me is not in that arrest report.
Yes,
So I
sir.
appreciate it.
Thank you, sir.
Thank you, sir. You can step down.
And Judge, Mr. Johnson has provided a sworn statement as well that I sent to the state attorney's office that is similar to his testimony here in the courtroom. In asking for bond, that's really what we're here for here today. And I believe that the state would be in agreement to lower the bond amount, which is currently at $10,000, or to change the $10,000 amount to a signature bond. I'll ask the state to speak to that.
Judge, at this point, our agreement would be for the $10,000 cash professional bond to be converted to a $10,000 signature bond based on the facts and circumstances that have come out from the defense's perspective.
Okay, thank you. Mr. Thomas, your dad being here, again, enlightened the court a lot from what I just read in the arrest report. And I think that probably impressed the state too, and that's why they converted it. That's unusual for them to agree to convert a $10,000 cash or professional bond to a signature bond. Certainly I have no objection to that, so that is granted. Your motion is granted. So you'll be able to sign out of jail today. Make sure you stay in touch with Mr. McKinney.
Procedurally, I believe Mr. Thomas was reset over to docket day on next Monday. So I would request a continuance until the November 13th pretrial.
Mr. Thomas, I'll see you back here November 13th at 9 o'clock. Mr. McKinney, Mr. Thomas still lives in Baton Rouge?
Yes, sir.
Yes, sir.
Do you want him to appear via Zoom, or do you want to waive his appearance for that?
Judge, I can always file a waiver of his appearance on pretrial. My hope and intention here is that we can do some motion practice in between now and the November 13th date. Once we get a full copy of the discovery, review that, and based on probably what the court has heard today in courtroom today, then there may be a motion to dismiss filed. That's all something I'm trying to get done before we come back on November 13th.
So I'll see you no later than November 13th at 9.
Yes, sir.
Thank you, sir.
Thank you. Thank you.
Next is Tykia Washington, who's also on the 130 docket.
Do you have the information for the 130 docket?
Washington?
What's that for you? Judge, this is Mr. Tykia Washington. He's here for an arraignment in 23 CF 1691, which is scheduled at 1:30 today. And I do have a copy of the one-count information for Mr. Washington, and then we can entering a plea of not guilty. This is currently scheduled for the November 13th date at 9 a.m. And I'd ask for the 23 CF 699 felony violation of probation to track with the 23 CF 1691 case on pretrial.
Yes, sir.
And I'd like the ability to add this on to an earlier docket if we're able to reach an agreement or if we need to do any motion practice.
Absolutely. Yes, sir. So you're in a denial on the VOP also?
A denial was previously going to but we've maintained the denial and asked for it to track with the new law offense.
So, Mr. Washington, I'll see you no later than November 13th. However, if your attorney wants to file a motion before that date, then we'll have the hearing before that. If the state offers you something that you think is in your best interest to accept, then Mr. McKinney can set that for a hearing as early as next week. Thank you, sir.
Next we have Eric Watkins, who's also on the 130.
Thank you.
Watkins?
Hello, Mr. Watkins. Good morning, sir.
How you doing today?
Good, how are you?
I see you the other day.
Yes, sir.
Yes, sir. What's your question?
I'm sorry.
Yes, sir.
The attorney answered this charge.
God bless you. Mr. McKinney, do you want to bring back Mr. Watkins at 1:30?
Judge, his question is super easy to answer.
Okay.
If you give me
Sure.
20
Yes, sir.
seconds. Judge. Judge, Mr. Watkins is on the docket this morning for a violation of probation, and on the docket this afternoon for an arraignment in 23 CF 1690. And the moving pieces as we look at it, and in the violation of probation, there is a reverse split, where there is probation on the front end, 60-month Department of Corrections sentence on the back end. So Mr. Watkins recognizes and understands that this new charge would violate his probation. And what the intention here is for Mr. Watkins to enter a plea to the bench in 23 CF 1690, which is the new law offense that's set for arraignment today, and admit to the violation of probation in 21 CF 2598 to have a sentencing hearing with Your Honor. There is no agreement with the state, and we are aware and we acknowledge that there is a reverse split sentence in 21 CF 2598. It is going to be difficult for the defense to get around at sentencing hearing, to be very blunt on the record. But Mr. Watkins wants the opportunity to address the court at a sentencing hearing. There is a mitigation evaluation that is pending, which I've already initiated. So that would control the timing of when the defense would be ready for sentencing. May I approach with this agreement?
If you'll just hang on to it a second. Mr. Watkins, we're taught in law school that the court can't change the terms of a contract. You know, in the civil world, I can't say, y'all wrote this, but I'm going to change it and you have to do something different. You know, the court just can't do that. A plea agreement is a contract, and so that's a default that all our legal minds go to initially. But there are a lot of appellate cases that say that the court can modify probation. No matter what the plea agreement says, we can modify probation, we can terminate probation. So it says the court has that discretion. My concern is if the plea agreement says prison, that's not probation. I have concerns whether I can change that. So, and that's why I don't want that plea agreement. The second is, it very well may be I have no discretion and I have to sentence you to, did you say it's 50 months?
It's a 60-month reverse split sentence.
60 months DOC, right?
2598.
So I have concerns that I would have to sentence you to 60 months in prison. I would rather us pass on this and make sure that everybody's up to speed. Your attorney really researches that, gives you his thoughts on that, comes back on the record and says, Judge, I've done research. I think you have the ability to do that. I've told Mr. Watkins that you don't have to, and that it's going to be a legal argument I'm going to make, that you have the legal right to do that. And that you understand that uncertainty. But if I had to do it right now, I'd say I have to sentence you to 60 months in prison because I don't know a way around it. So I'm not going to accept your plea today. Do we want to schedule it? Do you want to schedule it for next week in the afternoon or in the morning?
Procedurally, if we're continuing from today, then I think that the 23 CF 1690 should be placed on the pretrial docket on November 13th.
Okay.
And I believe that the 21 CF 2598 should track with that so that we don't have court dates that are not matched, and then we could add this back on to an early date or early plea.
Okay. That would be great. So, Mr. Watkins, I'll see you no later than November 13th, but if your attorney has a comfort level, about what we discussed and talks to you about that, and you want to still enter the plea, then I'll see you next week, okay? you, sir.
Thank you, Mayor.
Thank you.
Next is Lakeisha White, who's also on the 130 docket.
Okay, thank you.
Ms. White, court order 23 CF 1772. She is on the arraignment docket this afternoon for a 3-count information. And if I take care of that first, we'll know if we not guilty. In that case number, currently that's scheduled for the 13th of November, and we'd like to maintain that pretrial court date. For this morning, she's currently on the docket for a bond hearing. I have been notified by the 9-day mental health court diversion program. Let's see what they say. I can talk to you about that. Let's come back next week, so I can give you my advice. Okay. And because Ms. White has been evaluated for that 90-day mental health diversion program, that could have impact on bond conditions. I'm uncomfortable in going straight into the bond hearing without knowing whether or not she's approved of that program, and without discussing with Ms. White what that program entails and how it would impact her case. So I'm going to request a continuance of the bond hearing so that we can get an answer from the mental health court diversion program. Because I know that she's been deemed appropriate for that program, and it's been submitted to the state attorney's office for their approval. So we should get that relatively soon, probably by the end of the week, so I can discuss that with Ms. White. I would ask for the next available court date for Ms. White. If the court would allow us to put this on the 21st, I know that I'll have that answer by the end of the week.
Okay. So Ms. White, I'll see you in a week on September 21st, and that will be at 2:30. Well, do we want it in the afternoon, or do you want it in the morning?
It would be fine in the morning, Judge, because I don't believe that there would really be any testimony.
It's jury review. Let's still do it at 2:30.
That's fine. So Madam Clerk, we'd like to keep it on the 13th of November for pretrial, but continue to bond hearing only to 2:30 to the 21st September.
Judge, just to be clear, we just got the correspondence from pretrial either last night or this morning, and so we haven't really had time to go over it very much yet.
That is correct. I was notified that she was evaluated yesterday for that program.
It was 4:20 last night. That's okay. Thank you.
Next is Darius Wilkes.
Thank you.
Not on the one.
Hello, Mr. Wilkes.
How you doing, sir?
Good, how are you?
I'm good myself.
Good.
Do you understand?
Yes, ma'am.
We've reached an agreement in Mr. Wilkes' cases. That's 22 CF 1204 and 22 CF 1457. The agreement calls for Mr. Wilkes to admit violations of probation. He's previously been adjudicated, but he would be adjudicated guilty, and his sentence would be modified to an 18-month Department of Correction sentence with credit for time served. His probation will be revoked and terminated, and there's a $100 VLP fee and a $150 cost of defense.
Actually, it's $200, right? 'Cause it's
Correct.
Two
Yeah,
cases.
this is two case numbers, so that would be $100 in each case and a total of $250 cost of defense.
Yes, ma'am.
And outstanding financials will go to a civil lien judge.
Yes, Your Honor.
Okay.
May I approach?
Please. Mr. Wilkes, if you raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Wilkes, are you currently under the influence of any drugs, alcohol, or medication?
No, sir, I'm not.
Have you ever been treated for any mental illness or emotional disturbance, or are you suffering from any of those at this time?
No, sir.
How far did you go in school?
I graduated with my GED.
Good. I know that's self-motivated. Congratulations.
Thank you, thank you, thank you.
Mr. Wilkes, did you read the plea agreement?
Yes, sir, I did.
Do you understand?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
All the way, sir.
Did you sign the plea agreement?
Yes, sir.
Mr. Wilkes, I do accept your plea. I find that you're alert and intelligent, that your plea is freely and voluntarily entered, that you understand the nature of the charges against you,
Yes, sir.
and are represented by competent counsel with whom you state you are satisfied.
Yes, sir.
I find that there is a factual basis for acceptance of the plea. You're adjudicated guilty. Your current supervision is modified, and so it's saying the supervision is modified. It's really not supervision modified.
This is
The sentence is modified.
The sentence would be modified, and that's because this was last announced as a reverse split sentence. So that sentence is being modified per agreement to this.
Typically, Judge, a reverse split sentence, personally, it's something that I advocate very hard for. We do the reverse split as we have it written. In this case, in reviewing the reasoning that he was released from Phoenix House, the decision was made by me that this was going to be the most appropriate circumstance. The plea originally offered was for 18 months as it was, so we're not looking at a downward departure or anything like that.
Thank you.
I think it was just strange. I don't want to say that probation is modified because it's not. Probation is terminated. And the sentence, the prior split sentence, reverse split, is modified so that it's 18 months with the Department of Corrections with credit for all time served. You need to pay $200 in the cost of prosecution, $250 public defender's fee. Those amounts, as well as all other outstanding financials, will go to a civil legal judgment.
Okay, thank you.
You do have 30 days to appeal this judgment and sentence. If you wish to appeal, it must be in writing. If you cannot afford an attorney to represent you for that appeal, one may be appointed for you. Do you understand your appellate rights?
Yes, sir.
Thank you, sir. Good luck to you.
Judge, supervision is revoked and terminated.
Supervision is revoked and terminated. Yes, sir.
I have one question too.
Yes, sir.
When I pay my fees and everything, where do I have to come to? I come to the courthouse to pay my fees?
Yes,
Or
sir.
the court?
The clerk's office.
All right, thank you so much,
Thank
sir.
you.
All right, thank you, Mr. Buchanan.
We're going to get to this question.
It would be a score sheet.
Probably going to be VOP.
It wouldn't be a VOP, it would be the original score sheet would still be valid because we're modifying the sentence.
Judge, this is Mr. Michael Wilson before the court. Mr. Wilson is here for an arraignment on violations of probation in 21 CF 863 and 21 CF 3246. We're going to enter a denial and ask for this to be set for Monday. That's when his other underlying felony case is on the docket and set to trial.
Okay. So, Mr. Wilson, I'll see you on in the morning. Okay.
Yes, sir. On Monday morning.
Next is Tristan Whitworth. Judge, this is Mr. McKinnon's last name, if you want to take a break.
Thank you.
Yeah, I do have one individual to plead not guilty in the gallery for this afternoon.
Okay. Please, let's do that after this.
So Mr. Whitworth is approaching 21 CF 522. Judge, and Mr. Whitworth is going to be evaluated by Dr. McDonald. The court signed that, which appointed Dr. McDonald. I reviewed the order and made sure with Dr. McDonald that she had received it. She had not. So that is still an outstanding problem issue with orders related to competency getting to the evaluator. That being said, I know that Mr. Whitworth will be evaluated by Dr. McDonald rather quickly. I would ask for the next available date in October would be October 9th
Yes,
as a status date to see if we can get an evaluation back to proceed forward with this case.
I want to break this, but one
October 9th at 9 o'clock. Mr. McKinney, on the systemic point, do you have any idea where the ball's being dropped? Who traditionally provides it to the evaluator?
When an order is signed by the court that includes an email for the evaluator, typically the clerk emails that order to the evaluator. If it's done in-house from my office as a confidential evaluation, that step isn't taken, and we contact the evaluators directly. So I've made it my practice to contact the evaluators after the court has signed an order, but that's typically not something that's done, and not every attorney is going to look back behind that after the court signs an order.
And we got caught on that on one other one.
True.
Okay, so I'll follow up with the clerk.
If the court does a competency order sua sponte, it's something to look at as well to make sure that the evaluator is actually getting that order.
I agree.
You're gonna go straight here. Yeah, because you're here next to it, you'll see about the week off, and then if you're gonna come back for an
Mr. Whitwer, I'll see you no later than October 9th.
Yes, sir.
Thank you.
Judge, I do have Mr. Valentine, Ms. Valentine, is on the 130 docket.
Mr. Valentine?
He's been here all morning.
Good.
He's approaching related to a three-count information. We would waive the formal reading and include not guilty. This is already scheduled for November 13th at 9 a.m.
Mr. Valentine, I'll see you November 13th at 9. Okay. Good. Thank you, sir. Okay. We'll take a 10-minute recess and then we'll come back and finish up the morning.
I don't think it was much, so.
Thank you, ma'am.
All rise, please.
That's what we're aiming to do. I don't know, it might be a little more meaningful.
Also, just generally,
What are we going to do?
Nothing's gonna get done anyway.
Well, I'm gonna know attorney cases, he's gonna be like, yeah.
Well, surely Joe was gonna write down the offers. I mean, if he can do it, great, especially if he can do the 1:30 docket, then I'll have to plan to be here till 2:30. I'll give it to Joe and deal with that.
We're not doing turnage information court like picking them today.
My officers are coming in at 3 o'clock.
All right, let's do it.
Brooke, I got one with you. He's coming back, Josh was flaring out.
Okay.
The offer was 14 months.
We're doing that at 2:30. We had him until 2:30.
He's coming right back in.
Okay, well, he can wait till 2:30 right now.
Okay. All right, 10-4.
Oh.
Will do.
I mean, that's
rescue.
Do you have any kids?
No, sir. One on the way. Supposed to be due in April.
Okay. Is there anything else that I haven't asked you about that you want the court to be aware of regarding your bond situation?
I'm just hoping you let me come home so I can help take care of my bills and take care of my parents. They could really use me back at work.
I don't have any other questions.
To the state, any questions for Mr. McDonald?
No questions, Your Honor.
Okay.
Your Honor, we are not asking the court to do anything with the bond in the 1880 case. It's already been set at $2,500 cash or professional. We are asking the court to consider reinstating these two bonds in 23 CF 1469. In reviewing the first appearance paperwork, Your Honor, it does not appear that Mr. McDonald was put on pretrial services in either of these cases, although there is an order for no contact with the alleged victim in the 1469 case. I don't believe that Mr. McDonald, would you have any objection if the court required you to meet once a week in person with pretrial services?
No, sir.
Mr. McDonald would be more than willing to add a condition to his bond for pretrial services, weekly in-person reporting. He does not appear to be a flight risk. In reviewing the score sheet in the 1469 case, because I don't have discovery in the 1880 case yet, it looks like Mr. McDonald has 5 prior misdemeanors and 1 prior felony. He does score 76.8 points in the 1469 case. I have talked with Mr. McDonald. He is in my deposition process. So we are just simply asking the court to consider his ties to the community and allow him to have the opportunity to bond back out while these cases are pending. He did appear before the court 2 days before he was arrested. So,
Mr. Kleins, is anybody in the gallery for Mr. McDonald?
I don't believe so.
Okay, thank you. Okay, to the state?
Your Honor, yes, I just want to go through a brief facts of the case in this 23-1469 case.
Mr. Gomez, I did read and highlighted things both from the arrest report on July 1st, the incident that happened then, and also
The August 6th.
yes, sir, correct.
So I just want to make sure that I am good for the record on this. In this case, the things that I wanted to point out was that the incident in this case allegedly stemmed from the defendant was allegedly stealing kayaks and canoes from the victim. The victim approached the defendant, and at that time the defendant did hit the victim with his vehicle, and then not only hit him one time, actually turned around and tried to come back and hit him again. He got a pretty reasonable bond given those charges, with a $15,000 bond on the aggravated battery and a $10,000 cash professional on the aggravated assault. A little over a month later, he has another incident, and I'll be quite frank, if we were sitting here and this incident may have been something to deal with some drugs or something where we're not dealing with a victim, I think the state's position is different. But I think that case highlights that this defendant has a particular issue with managing anger problems, and that presents a very serious concern for the public. I spoke with the victim in this case, in the 1469 case, to get their opinion. That victim is dealing with a lot of anxiety right now surrounding this incident, and actually had anxiety beforehand. The victim is extremely concerned about this defendant being let out. I think it's clear between this incident as well as the August 6th incident that this defendant does have a hard time keeping his anger in check. Given that, I think that he does pose a threat to the public, as he is illustrated particularly on both of his dates, but he's out on bond and then is seen kicking someone's door multiple times to the tune of a couple $1,000s worth of damage while the person is in the vehicle. Given that, the state would respectfully request that this bond remain revoked in the 23 CF 1469 case.
Mr. Kleins, finally?
Your Honor, I would just point out there's no evidence before the court that he's a danger to the community. Nobody's testified. That's just argument coming from the state. Mr. McDonald has not been found guilty of anything. He's not admitted anything. He does know the alleged victim in the 1469 case. They used to be friends. Mr. McDonald has a drastically different version of events that happened that evening. So we are simply asking the court to consider it. I will
halfway concede that Mr. McDonald does seem like he does probably need to relax a little bit, but he's going to be living at home with his parents, he's going to be working with his dad, and he doesn't appear to be a flight risk.
Thank you. Mr. McDonald, when the state was speaking, and also when your attorney was speaking, I nodded. I don't nod necessarily that I agree with the argument that they're making, but I understand what the argument is, and so that's why I nod, just in acknowledgement of, done my homework, I've looked through things, I understand what their argument is. Mr. McDonald, based upon primarily what's in the 2 arrest reports, respectfully, your motion to reinstate bond is denied. So you'll be held without bond. Will I see Mr. McDonald on November 13th?
The 1469 case has already been continued to the 13th. He does have an arraignment next Thursday in the 1880 case. As soon as I see an information, I'll file a written not guilty plea.
Okay.
And I would ask, once that not guilty plea comes through, to keep both of these cases on the 13th,
Yes,
November 13th.
So I'll see you no later than November 13th. Thank you, sir.
Can I approach with an order?
Yes, sir. Thank you, sir.
Devin Morales.
Your Honor, this is Mr. Morales in 22 CF 2511. He was recently arrested in 23 CF 1936. That case is on the October 12th arraignment date. I would ask to continue the 2511 case to track with the 23 CF 1936. We are attempting to reach a mutual resolution to resolve both cases. I talked with Mr. Morales today, and I do have information. I will be filing a bond motion, so I expect the court will see him again next week. But as of right now, I would just ask to put the 22 CF 2511 case on the October 12th docket to track with 23 CF 1936.
Okay. So, Mr. Morales, I'll see you no later than October 12th. But if your attorney files a motion, then I'll see you next week.
Okay, what day this week, do you know?
It depends on when he files it, depends on which date.
I believe it'll
either
be the
be Monday or
21st.
Thursday.
Yeah, okay, all right.
Thank you.
I'll see you next week.
James Moss.
Your Honor, this is Mr. Moss in 22 CF 318. We will enter a denial in this particular case. He does have 2 new law violations in 23 CF 1909 and 23 CF 1910. I would ask, and both of those cases are on the October 12th arraignment docket. I would ask the court to continue the VOP case to the October 12th docket. We are trying to work on a mutual resolution here for resolving all 3 cases.
Okay, good. Mr. Moss, I'll see you no later than October 12th. Thank you, sir.
Next we have someone more.
Hello, Ms. Morris.
Your Honor, this is Ms. Morris in 23 CF 1802. She's before the court on a motion to reduce bond. I talked with Mr. Gomez. I believe the state's going to stipulate to this motion.
That's correct, Your Honor.
And just so the court's aware, Ms. Morris is going to be taken into custody by the marshals. There's a current marshal hold on her. I have talked with her public defender in Montgomery. She has a federal public defender up there. And so we're going to be transferring her over to the federal system, and I will reach out to her public defender and keep tabs on this. I've already instructed Ms. Morris, if she's released from federal custody, she needs to call my office, and her case is going to be on the November 13th docket.
Okay, good.
May I approach with an order?
Yes, sir. So, Ms. Morris, as far as my case goes, November 13th at 9 o'clock, okay?
Yes, sir.
And I am signing your very unusual set of facts. When I was doing my homework, to be honest with you, I was curious what I was going to rule because I wanted to hear what was going on. So I'm glad that they stipulated to it. I'll see you November 13th, okay?
Yes, sir.
Thank you, ma'am.
Okay. She's set for next week, or you guys going to not guilty?
Yes, thank you for mentioning that, Madam Clerk. Your Honor, there is a 2-count information in 23 CF 1802. We would waive the formal reading and enter not guilty plea.
Thank you. Thank you, ma'am.
Thank you.
And the last one I have on the docket, Your Honor, was Arnold Pennell on 22 CF8. I talked with Mr. Pennell. I have the PTI agreement. I will email this to Ms. Veras today.
Good, thank you.
So does the court want to put this on for the October 9th docket for status?
Yes, sir, that'd be great. Okay, so hold on one second. Okay, so October 2nd on which case?
October 9th.
October 9th?
On 22 CF8. And that'll just be PTI status.
Thank you.
That's all I have.
Good, thanks, Mr. Pines. Mr. McKinney, Mr. Koch?
We have a suspense who's an inmate with Mr. Nopes. I don't know if you know anything about what's going on there.
If is that one of
Douglas Spence on notes.
I heard Mr. Nopes this morning.
You want to just pass it until 2:30 and I'll try to get in touch with him?
It's just that's fine. We also have the inmates for the 1:30 docket. If we can go ahead and handle those this morning.
Do y'all want to do those?
um,
The arraignments?
I'm fine with mine.
They're going like 5.
Okay, yes ma'am, that'd be good, thank you.
You can put the inmates for 1:30 in the feed. First we'll have Dion Pounds. He doesn't have an attorney.
Thank you. Gentlemen, the two gentlemen that are waiting in the gallery, who are they waiting for?
One's just a spectator and one's here for Miss Sharman. It's on the 1:30 docket.
Okay, thank you. Good morning.
Your Honor, this is Dion Mount. I guess I don't represent him in 23 CF 1711. I do represent him on a number of other cases. If the court would appoint our office on the 1711 case.
Mr. Mount,
Yes, sir.
has your financial condition gotten any better since you were appointed the public defender in your other case?
no, sir.
Okay. Do you wish for me to appoint the public defender in this case?
Yes.
Okay. You want an attorney?
Yes, sir.
Okay. I do appoint the public defender in 23-1711.
And, Your Honor, we do have a two-count information. We will waive the formal reading, enter a not guilty plea. I can tell the court that Mr. Mount went to drug court yesterday on the cases I represent him on for observation. So hopefully the court will not see him again. But if we could put this 1711 case on the November 13th docket, his other cases have already been continued to that docket.
Yes, sir. Mr. Mount, I hope you get in drug court.
Thank you, sir.
Yes, sir.
Next we have Anthony Patterson and Mr. Fox.
Thank you.
Yes, Your Honor. Information has been filed. We'll be entering not guilty and waive formal readings. My client has a separate case, and he will be in front of you on Monday for it'll be a global plea or a trial on that separate case. So we'll
Okay.
be seeing him Monday.
Okay, Mr. Patterson, I'll see you Monday, okay? Okay. Thank you, sir.
I'll see you tomorrow.
You
Coming
coming
in.
in?
Yep. Yep. Thank you, John.
Thanks, Mr. Coe.
Next we have Michael Rona.
Judge, I have Michael Rona stand next to me. We'll be entering not guilty. Information has been filed, and we'll waive formal readings. And if we can have this, keep it set. I believe it's for the 11/13.
Okay, yes, sir. So, Mr. Rona, I'll see you no later than November 13th. If your attorney wants to schedule a hearing before that date on a motion, or if the state offers you something that you want to accept as far as a plea, I'll see you earlier than that. Thank you, sir.
Next we have Jennifer Sharman.
Judge, may I have just a brief moment?
Yes, sir.
Thank you, Judge.
Yes, sir.
We'll be entering not guilty and waive formal readings and keep this set on, I believe, 11/13
Okay.
docket.
I'll see you no later than November 13th.
Yes, sir, thank you.
Thank you, Madam.
Thank you.
And November 13th, to the father, or November 13th, it'll be at 2 o'clock via Zoom for if she's an inmate, okay? Yes, sir. So it'll be, no, that's fine. 2 o'clock on the 13th if she's still an inmate, and she'll appear via Zoom. So she may not be able to see you in the gallery, but just wanted you to know that.
She's amongst over.
Yes.
Thank you, sir. Mr. McKinney?
Yes, Judge, this is Sean Tillman before the court. Mr. Tillman is before the court in 23 CF 1697. Just looking at the paperwork.
Yes, sir.
In that case, there is a one-count information. I'll waive its formal reading, enter a plea of not guilty. I believe this is going to be scheduled for the November 13th court date for a pretrial. Additionally, Madam Clerk, there are 2 violations of probation that are tracking along with this new case, which is 18 CF 2512 and 22 CF 1348. So I would like them to track along with the new law.
Mr. Tillman, until I heard about the violations of probation, the alleged violations of probation, I was wondering why the state wasn't making an offer for you for this case. Now I understand why, but I'll see you back here no later than November 13th. If the state offers you something that you want to accept, I'll see you before that date.
Yes, sir.
Thank you, sir.
Thanks.
Judge, there was one case, because I'm going to be gone this afternoon on my trip, that I wanted to address, so that way there was no confusion. The case is Justin Pridmore. It's 23 CF 1699.
Okay.
The state is actually, I wanted to announce a dismissal. I spoke with the victim.
It's an arraignment?
Yes, it is an arraignment, out of custody. The victim had submitted a drop charge request. I called the victim personally and spoke with the victim. She stated that she was not ever the one that actually wanted to press the charges. It was a friend of hers that was extremely intoxicated and really didn't have any idea what was going on. So at this time, the state is going to dismiss 23 CF 1699 at the request of the victim, as the victim declined to prosecute.
Okay. And I still don't find that on my docket, but.
It's on the plea day docket.
Right, arraignments. And how do you spell the last name?
Pridmore.
Got it. So that's Mr. Koch's?
Yes, Judge.
Okay. So you'll let your client know that it's dismissed?
I'm going to call on you, Judge.
Good. And that case is dismissed. Good. Okay.
Your Honor, just for your knowledge, I believe ASA Davis is going to be covering my sentencing hearing this afternoon, so if I may be excused.
Yes, sir, absolutely. Thank you, sir. Make sure we're in recess until 1:30.
All rise, please.